director precluded him from being a servant of the respondent company, thus he is not entitled for compensations. Good morning, ladies and gentlemen. Calling for the case Lee and Lee Air Farming Limited. Are both sides ready?
Ready for the people, Your Honor.
Ready for the defense, Your Honor.
Lawyer appellant, you may start with your statement.
Your Honor, I am representative of Mr. Catherine Lee. The appellant is the deceased wife. She wants to claim a workman compensation under New Zealand workman compensation legislation. Your Honor, the deceased was a worker and drive in aircraft accident in Canterbury, New Zealand on 5 March 1956 while engaged in the capacity of aircraft pilot in aerial top dressing operations. Your Honor, the company employed Mr. Lee as the chief pilot of the company at a salary of £1,500 per annum from the date of incorporation of the company. In respect of such employment, the rules of law applicable to the relationship of master and servant shall apply as between the company and to the said Geoffrey Woodhouse Lee. Your Honor, in this case, my client deserves to get compensation for herself and for her 4 infant children as well as the funeral expenses. Thank you, Your Honor.
Respondent lawyer, you may start with your argument.
Your Honor, I'm the representative for Lee Air Farming Limited Company. Your Honor, on the 5th of August 1954, Lee Air Farming Company was incorporated and Mr. Lee was appointed as the governing director of the respondent company. And the secretary was Mr. Sajjan, a public accountant and a member of the firm's public accountants who were instructed the deceased to form the respondent company. The deceased at the time of the accident was the controlling shareholder of the governing director as well. Therefore, he cannot be considered as a worker within the meaning of Workers' Compensation Act 1922 and its amendments. Thank you.
Objection, Your Honor. I am very sure in law there is no reason why a person could not perform corporate function and employee function at the same corporation. As in the Lee case, Mr. Lee can be an employee and employer at the same time. Thank you, Your Honor.
Based on Workers' Compensation Act 1922 and in relation to the facts of the case, the deceased could hold the office of governing director of the company as well as the servant of the company, as they are 2 separate legal entities. With reference to the case Salomon and Salomon, it be accepted that respondent companies was a legal entity. Hence, the respondent company must pay the costs and compensations to appellant. Court dismissed.